prepared in such a manner that we are going to have, I'm going to use more, like Mr. Dini pointed out during his introduction, that I'm going to talk more about the prosecution between the US and Europe, kind of a bridge, how you're going to compare these two systems. So basically, I'm just going to point one single point on the unitary patent system, about the code structure. That's the only thing I'm going to talk about there. And then with regard to the prosecution, I'm going to touch upon going to talk a bit on the global patent application, which it's a quite a tough task to achieve, because of course, the ideal thing is to draft a patent application which you can have it granted in all the jurisdictions where you would like to have. But in reality, to draft such an application is really a very tough task. So I'm just going to highlight certain issues which you need to consider when you are thinking of different jurisdictions, and especially for an Indian scenario, US market is a very huge thing for an Indian company. So most of the times, Indian applicant would try to draft his application in a US format, and then we would be asked we would be given instructions to enter the national entry using this application. So I'm just going to give you some issues what are the things you should consider from the European point of view as well. And then I'm going to try to answer this question: can a prosecution highway help you? And I'm going to briefly touch upon the last topic, which is on freedom to operate. I'm just going to give you an overview of what you should consider for this particular topic. So coming to the EPS, as I said, I'm just going to talk about the unitary patent code system. So it's a good initiative. But it's like any system, when you want to introduce it, it always will have some positive and some negative aspects. I think I look at it in a very positive approach in the sense that the unified patent code is going to be more like the US system, where you're going to have one code which is going to deliver a decision which is going to be used for the entire UPC states. The positive things I could say is you will have a more predictable decision with a single outcome, which you can use it for the entire states. The negative aspect would be you have all eggs in one basket. So if with one attack, you will just knock off the entire protection in all the UPS states. This might be an issue which a lot of companies might consider. This is a decision where they will take, should I enter the UPS system, because this is a risk I might run, and some companies may say, well, maybe it's okay. So it depends on the company, whether on the area of the expertise, where on the field where there is more litigation or there is less litigation. So a company which has less litigation, a manufacturing company, let's say, who has less litigation in that area, maybe he might consider UPS as one of the options, because the risk of having this attack and this litigation is probably minimized. The one question, of course, is, will the UPC be looked at as a district court or a federal circuit in the US? We have to wait and see, I must say. So, but I do have an optimistic view here that since the judges are going to be specialized and they're going to focus on one particular aspect of IP law here, so I think over the years, I think it will turn out to be quite equivalent. So I'm going to skip these slides, and then coming to the coordinating of the global patent application. As I mentioned, you always want to draft an application which you can use in more than one jurisdiction. So here I would like to just highlight certain issues you should consider. The first thing is, regardless of any jurisdiction you are going to go for, you still have to describe your invention in a manner where the technical effect is identifiable. So this, I'm sure, is going to be applicable in all jurisdictions wherever you are going to apply. If you were to take, let's say, a US application and then enter into a national stage, one thing you must watch out is multiple dependency. So in the US, it's not allowed because the claim fees would be higher. So you need to remove that. But in Europe, it's allowed. So you could add multiple dependencies. But in Europe, what's important to consider is the claim costs. So if you go more than 15 claims, one of the speakers here had clearly pointed out, he stressed on the word 15. The reason is because from 16th claim onwards, you have to pay 225 euros per claim. It's a lot of money. And if you cross 50 claims, it's 555 per claim. So you can imagine a chemical application, especially which has 100 claims, you can imagine you're going to really burn a lot of money just by paying claim fees. The next aspect is incorporation by reference. If you see in a US application, there would be, in the specification, it's often mentioned, a particular application is mentioned or a particular reference is mentioned, and then it would say incorporated by reference in its entirety. So when it comes to Europe, you just can't use that kind of a thing. You have to delete these. The examiner will ask you to delete all these texts. So the US in this case has a more liberal approach. And then the next point is the Article 123.2. I think my previous speaker had clearly defined the problems you would encounter when you want to amend your application. So one big issue is between the US and Europe, you have to understand US has a more liberal approach with respect to amending your claims. Whereas in Europe, you have to understand that every time you amend your claim, you have to find basis in your specification. So your specification is extremely important, and you have to plan very well at the time of entering the pre-phase, or at the time of drafting, in fact, that you put extra embodiments to cover all possible amendments you would want to make in the near future. And then the next thing is you have to be aware of the inequitable conduct in the US. So one good example I have here is the Becton case. So here the district court found the patent unenforceable for failing to disclose its statements made to the EPO. In the counterpart European application. So here you see you really have to make sure you are consistent in the way you prosecute applications in different jurisdictions. So what you say in one jurisdiction might harm you in another jurisdiction. So you really have to be careful about this. The last point in this one I like to mention is to be careful about the prior art effect. So this prior art effect, I'm just going to focus on is the ones where it's earlier filed but later published applications. Under the new AIA system, such applications would be cited against you for both novelty and inventive step. Whereas in Europe, it is we have this thing called Article 54.3 citation. That means that particular reference, when it has to satisfy certain requirements, and some of the requirements are that you have to enter the Europe, and you have to have in the specification in one of the languages. And in these kind of instances, this is only applicable for novelty. So you have to understand this difference. So when you draft your application, you might say, okay, fine. Most of the times, this is a case where it's your own application, your own second application for your filing, and there you would often think about if you just think about Europe, you say, okay, fine, I can get over this problem. It's just I have to just make my claim novel. But then you have to realize, under the new AI system, you will have problems in the US. So this is something you have to be careful about. So again, strategy is very important in all these cases. Coming to the next topic, patent prosecution highway. I assume that everybody knows here about this, so I'm not going to go in details what exactly is a patent prosecution highway. But it's basically a system, in short, it's basically a system to accelerate your grant in one using the results of one jurisdiction. You accelerate your grant in another jurisdiction. So here you see in this slide there are lots of patent officers who are having lots of projects in pilot programs in trying to work out on this system. But I must tell you, how does it work in the EPO? There's a bad stuff of it. So if you were to file a request at the EPO, it's not very good, I must say, because here is a slide which is from the European Patent Office. This is a survey which was done with the patent examiners, and as you can see, The first one says 23% of these examiners, of the surveyed examiners, state that the work provided by the Office of First Filing was useful. So only 23% state that. The next one is a killer, in fact. In 13% of all these responses, the examiners state that having the Office of First Filing work results made processing of the application efficient or very efficient. So only 13% said that. That means 87% said it's inefficient, right? So it's really not a good thing. And if you look at the statistics, there are not much filings anyway at the request at the European Patent Office. 56% of the users, of course, were very happy with the translations things from, because if you see, Japan is one country which uses a lot of the prosecution highway a lot. So the good stuff is that the USPTO, however, likes this. So they seem to have a very good allowance rate, and it does accelerate the proceedings in the US. For the Indian scenario, I thought also a good option to consider would be to have a granted UK patent, because it's quite quicker, it's cheaper, and it's quite quicker to have a UK patent. And maybe you could file a prosecution highway request in the US based on this one. So if an Indian company wants to accelerate their thing, maybe this might be a good alternative to think about. Coming to the last topic, overview of FTO analysis. The first and the most important question is, will the third-party patents impact your business objectives? This is the first question you have to answer. And then, of course, the rest of the things follow automatically. You do a search, you try to identify the potentially relevant third-party patents and applications. You determine the scope of the third-party patents, you compare the claims to the product, and you also try to think about how to manage the risks associated with these FTO issues. You might consider what are the third-party challenges. So I'm just going to briefly list all the third-party challenges you can think about. So here is a slide where I try to show you a comparison between US and Europe. If you see on the left side, there are many options in the US, and this is the post-AIA. So you could see there is a pre-issuance submission, a third-party submissions, there is ex parte re-exam, there is post-grant review, there is inter-part review, and there's litigation. These are the things you could consider. In Europe, you would see that there are lots of parallelism there. You could see for the pre-issuance, there is also an equivalent one in Europe, which is we call it the filing of observations. And this can be done not just at the pre-issuance stage, also during the post-grant stage, especially when the European patent is being opposed in the opposition period. You can also limit. You can also have a limitation proceedings where you could change your claims. If you want to go after an infringer and you see there's a potential prior art, you might want to consider to have a limitation procedure, initiated limitation procedure, and then amend your claims accordingly, and then go after your infringer. There's also oppositions in Europe. It was always there. What is surprising thing, if you see in the US with the post-grant review, they also have 9 months from grant. So there are a lot of people asking this question, why 9 months? So is it because the Europe have this opposition period for 9 months? Are they taking something from from Europe or something? Yeah, this is an interesting question, in fact. Like in the US, you also have litigation system, both in the national courts, and probably in the future you will also have it at the European Patent Court. So you might ask the question, with all this harmonization, you might ask maybe they are trying to harmonize the systems, at least from the US and the European perspective, maybe they are trying to harmonize. That ends my talk, and thank you very much.
Panel lasted a little bit more than what they gave us as a time. So if there are some short questions from the audience, we will try to reply. Otherwise, we can have a coffee break. So if there are questions. if there are no questions, means that the speakers were enough supported by the description. Okay, thank you everybody for your patience. Have a nice coffee break.
Today's keynote speaker is Mr. Keval Likhani. He's a President and Executive Advisor, IP2 Revenues LLC. He is the past chair of the Strategic Alliances Committee at the Licensing Executive Society and Ad Hoc Committee on IP Issues in Asia, particularly in India and China, as they relate to licensing and commercialization of IP. I would like to welcome him with a memento.
Thank you very much.
Mr. Colin McCall, we would like to welcome you with a memento.